off at workers' compensation, and now we're going to talk about ADA, and we're talking about the disability part of what falls under the ADA law. So here, what you're seeing is, it says a disabled employee who is still able to perform the essential functions of the job. Now, keep in mind, it is you have an employee who's disabled. In order to do the job, they have to actually be able to perform the essential functions of the job. So there's a lot of things that employers have to actually prove on their end of it. So it says, entitled to return to their same position unless the employer demonstrates that holding open the position would impose an undue hardship. Now, we've talked a couple of times in this process about what an undue hardship is, and we'll talk about it again, because it is one of those situations where you have to really prove as an employer that it really is an undue hardship. You're not just going to lose a couple $100 in sales. Where the ADA disability is due to a work-related injury, the employer cannot refuse to return an employee to work because it fears increased risk of re-injury and increased workers' compensation costs. I'm sure that all of you have been in the position at some point where somebody has a back injury and you really don't want to return them to work because you're worried about exacerbating their current injury. You can't really do that. What do you have to do before you return an employee to their current work title?
Get a doctor's release form.
Very good. Yeah, that's exactly right. So instead, the employer must show that the employee poses a direct threat to themselves or others. So even if you have this release from a doctor, if you have your job descriptions done and they are including all of the specific requirements, you know, you guys, I hope you guys know the drill. You want to include in every single job description that you have that this person has to be able to use their fingers or hands, bend over, move, push, you know, all the different things that are involved physically in their job, and in some cases mentally as well. And so at that point is when we would look at bullet number 2. Instead, the employer must show that the employee poses a direct threat to themselves or to others. So if they can't do all of those things, then that is what they're going to do. Of course, even if the employee does pose a direct threat in that particular position, the employer may have reassignment obligations. In addition, an employer may not require an employee with a disability-related occupational injury. Now, remember, right now we're talking about workers' compensation and how it combines with ADA and the Fair Employment and Housing Act. So I know, you know, we left at this point last week at 12:30, and so we have to kind of get back into the headspace of where we were at the time. So long as the employee can perform the essential functions of the position with or without reasonable accommodation, she must be allowed to return unless the risk of substantial harm could not be reduced to an acceptable level with a reasonable accommodation. Again, since reasonable accommodation may include reassignment to a vacant position, the employer may be required to consider an employee's qualifications to perform other vacant jobs, not just the job the employee held at the time of the injury. Of course, an employee returning from leave is entitled to return to the same or equivalent position. An equivalent position is a position that is virtually identical to the employee's former position in terms of pay, benefits, and working conditions. An equivalent position must have substantially similar duties, conditions, responsibilities, privileges, and status. We've seen situations where somebody actually moves into an hourly role when they were a manager, and they sued because of the demotion, and of course they won. The employee must be reinstated to the same or geographically, this is another thing, proximity, work site, and return to the same shift or the same or an equivalent work schedule. Equivalent pay includes returning to a position averaging an equivalent amount of overtime. What happens if, at the conclusion of a FMLA leave, the employee informs you that his serious medical condition is permanent? They may have a disability that prevents them from performing the essential functions of the job held at the commencement of the FMLA leave, and there is no available accommodation. So when an employee is determined permanent, that is by the doctor and the workers' comp group. We have nothing to say about that. The FMLA assumes that an employee will be qualified to return to his or her position at the conclusion of the leave. If the employee is not so qualified, the regulations provide the following. If the employee is unable to perform an essential function of the position because of a physical or mental condition, including the continuation of a serious health condition, the employee has no right to reinstatement to another position under the FMLA. Now, remember, we're talking FMLA, okay? Workers' compensation, of course, has their own rules, but they combine with what happens with the FMLA. However, the employer's obligations may be governed by the Americans with Disabilities Act. So these regulations they're long and lengthy, and sometimes they're not. Sometimes they're just a paragraph. Based upon this regulation, if an employee is not capable of performing the former or an equivalent job, the ADA's reasonable accommodation requirements are to be followed, not the FMLA reinstatement requirements. Now we're going to move out of workers' compensation. We're going to talk about pregnancy and how it combines with the Fair Employment and Housing Act. Now, keep in mind that pregnancy disability leave is actually a part of the Fair Employment and Housing Act. So subject to narrow exclusions, an employee returning from pregnancy disability leave has a right to reinstatement to the same position and has the right to a written guarantee of reinstatement from the employer upon request. Reinstatement to a comparable position is permissible only in limited circumstances. An employer may refuse to reinstate the employee to her original position if the employer can prove by a preponderance of the evidence that either one, that the employee would not otherwise have been employed in her original position at the time the employee requested reinstatement as a result of legitimate business reasons unrelated to the employee taking a pregnancy disability leave or transfer, or two, that the employer's means of preserving the job or duties for the employee, such as leaving it unfilled or filling it with a temporary employee, would substantially undermine the employer's ability to operate its business safely and efficiently. Further, an employer may justify its refusal to reinstate the employee to a comparable position by showing by a preponderance of the evidence. Remember, in this situation, we don't want to get into a lawsuit, but these are the things that the attorneys are going to look at, and they're going to use that term, preponderance of evidence. That one, no comparable position is available, or that the employee took a pregnancy disability leave that did not qualify as a FMLA leave. Under what circumstances? I'm going to keep going, but right, and you should have learned this already. Under what circumstances would the employee not qualify for a FMLA leave? Okay, and filling the comparable position with the returning employee would substantially undermine the employer's ability to operate safely and efficiently. Okay, under what circumstances? If an employee at the expiration of a pregnancy disability has taken a CFRA child bonding leave, the employee's right to reinstatement is governed by the CFRA and not by the Fair Employee and Housing Act. Under the CFRA, the employer may reinstate the employee either to the same or to a comparable position. Workers' compensation laws. So if it feels like we're skipping around, remember what we're talking about right now is which laws combine together. All right. The courts have granted employees broad reinstatement rights following leave taken because of an industrial injury. They have interpreted Labor Code Section 132A, and we can't push it into our brains enough, because if we do get into some trouble for this, that's the first thing you're going to see is, yeah, I'm getting a 132A claim. So Labor Code Section 132A's prescription on discrimination to require an employer to reinstate an employee following a leave due to an industrial injury unless denial of reinstatement is necessitated by the realities of doing business. The burden of establishing such business realities is on the employer. The two principal situations in which courts have upheld terminations and/or refusals to reinstate industrial injured workers based on business reality are: one, the employee is permanently disabled from performing the job, and two, no work is available that the employee can perform without the risk of re-injury or further injury. An employer may be able to permanently replace an occupationally injured employee if the employee's condition is deemed permanent and stationary. And the permanent limitation is such that the employee is not able to perform his job. If an employer replaces an employee before then, the employer must be able to prove that the business realities required the employer to do so. The employer's burden of establishing business necessity may be difficult if no hardship results from temporarily filling the job, or if other employees could have handled the injured worker's job duties while he was temporarily disabled. Employers should think of the business realities defense as similar to the ADA's undue hardship. So these are the things that we as human resources practitioners do to prevent getting into a courtroom where they begin to use this kind of language. All right, now we're going to move away from hardship and, having to prove our side of reasonable accommodations and that kind of stuff. And we're going to talk about looking about how we combine the ADA, FMLA, CFRA, and FEHA. So with disability and pregnancy, and can we have reduced schedules or part-time work? Under the ADA, part-time or modified work schedules may constitute reasonable accommodations under the ADA. However, an employer need not provide such a schedule if part-time work is an undue hardship or a full-time schedule is an essential function of the position. The employer does not need to maintain the same level of benefits if it does not generally do so for part-time workers. Under FMLA and CFRA, an employee is entitled to take FMLA or CFRA leave intermittently through a reduced schedule. The employee's benefits must be preserved during reduced schedule leave. The employer must continue to pay its share of health insurance costs, and an employee can remain on reduced schedule leave until he uses up his annual allotment of FMLA leave. And 3, under the Fair Employment and Housing Act, employees who are pregnant may take pregnancy disability leave intermittently or on a reduced work schedule when medically advised, as determined by the woman's health care provider. All such leave. So when you have somebody, and this happens to my clients all the time, they have morning sickness, they're not feeling well, it's the first 90 days of their pregnancy. They don't just get to go on FMLA leave. You must still get, they do just get to go on FMLA leave, but you must still have a documented note from a healthcare provider. The employer may require a pregnant employee who is on intermittent leave or on a reduced work schedule to transfer into an alternative job. The alternative position, however, must have equivalent pay and benefits. The employee must be qualified for the position, and it must better accommodate recurring periods of leave than the employee's regular job. The reason why I don't like the way this sentence is written is because you can't force a pregnant employee to go to a different job. You can ask them. So it says the employer may require, and that's not quite true. So keep that in mind when and if you have a pregnant employee, and they, for some reason, we can show as a business necessity that they can't do the intermittent leave, then it's important for us as HR practitioners to take a look at the whole big picture on doing anything with them in changing their job. You may ask them if they would like to, but you may not require them to take a reduced schedule or to transfer into an alternative position. So that was under pregnancy leave. Now we're moving over to ADA and FEHA, transferring them to another position. Now this is a little bit different, and keep that in mind. Pregnancy disability leave has much more stringent laws that you'll find on any of the other disabilities. An employee may offer as a reasonable accommodation a transfer to a vacant equivalent position or to a position that will be vacant within a reasonable amount of time. In general, reassignment should be considered only when accommodation within the individual's current position would pose an undue hardship. The employer cannot unilaterally reassign an employee with a disability-related occupational injury without first trying to accommodate the employee in the position she held at the time the injury occurred. If there is no such vacant equivalent position, the employer may offer an employee a transfer to a position with a lower salary when no other reasonable accommodations would allow the employee to stay in her current position. The employer need not maintain the original position's higher salary. So this goes against everything that we know when we're talking about an employee with a pregnancy disability leave. And we've seen employers make this mistake mostly outside of California, because in California, we have much stricter protections for women who go out on pregnancy disability leave. If there is no such lower paid vacant position, the employer is not required to create a new position or bump another employee from his position. FMLA, CFRA. Since FMLA and CFRA govern leaves of absence, not transfers, these issues do not typically come up under these statutes. However, an employer may require an employee to transfer to another position if the employee needs intermittent or reduced schedule leave and the position to which the employee is reassigned better accommodates the leave schedule. The benefits and pay of the original position must be retained. The employee is entitled to reinstatement to the original position when the need for intermittent reduced schedule leave ends. Let's look at what FEHA says about pregnancy. An employer must grant a pregnant employee's request to transfer to a less strenuous or hazardous job or job duties when the employee's health care provider certifies that the transfer is medically advisable and the employer can do so without an undue hardship. The employer need not transfer the employee into a position for which she is not qualified, create a new position, discharge another employee from a position to make room for the pregnant employee, or violate the terms of a union contract to do so. In addition, the employer may require the employee to temporarily transfer to an alternative position if the employee takes pregnancy disability leave on an intermittent or reduced schedule work basis. The alternative position must have an equivalent rate of pay and benefits. The employee must be qualified for the position, and it must better accommodate recurring periods of leave than the employee's regular job. The temporary position does not have to have job duties equivalent to the employee's regular position. So this is really interesting, and I think where I'm getting confused on this is they're using the word require for intermittent or reduced work schedule basis. What I'm thinking is it may be allowable for an employer to require that, but I think it would be hard pressed to actually prove it as a hardship on the company. So any place I have ever worked, we ask the employee if they would like to do that. They have always said yes, because in every case, it's more beneficial to them. Transfer to another position, workers' compensation. Employers must be cautious in transferring employees who have been who's had a workers' comp injury, where the transfer is detrimental in some way, such as to a position with lower pay or benefits. It may constitute unlawful discrimination under Labor Code 132A, unless the employer can demonstrate that the transfer was necessitated by business realities. So we're seeing this over and over again. And one of the reasons why I chose to use this set of laws, this is actually the legal language for this stuff, is so that when you walk away from this class, you will have a grave understanding of how critical it is for an employer to be able to make any type of business necessities. It has to be good. For any time that you're going to change an employee's position, maybe not allow them to come back. And it all has to be done not by HR, not by senior management, but in Congress with the workers' compensation people, with the doctors, with the employee. Everybody has to have some input into this. Light duty. Now, light duty was something I was really big on. And you have to be careful, though, because you can't take somebody who is working on working as an HR assistant and make them go out to the assembly line. So you have to be really careful how we work on that. Job restructuring or job modification is another form of reasonable accommodation under the ADA and may involve relocating or redistributing the marginal functions of the job. However, the ADA does not require an employer to relocate the essential functions of the job to accommodate an employee's disability. Thus, employers are not required to create a light duty position for an individual with a disability unless the heavy duty tasks of the position are marginal and not essential to the job. It may be a reasonable accommodation for an employer to reassign an employee to an existing vacant light duty position on a temporary basis. However, be aware that if an employer assigns a disabled employee to a vacant light duty assignment, it also must provide them with any reasonable accommodation necessary for them to perform the essential functions of the job. And according to the EEOC, an employer is free to determine that a light duty position will be temporary rather than permanent. Thus, an employer need not transform a temporary light duty position into a full-time regular one. So remember here, what are we talking about? We're talking about ADA and Fair Employment and Housing. ADA is federal, FEHA is California. Accommodating employees with work-related injuries raises questions concerning the employer's ability to reasonably accommodate otherwise qualified employees and applicants with disabilities. First, an employer must consider reassigning non-occupational injured, disabled employees to vacant light-duty jobs. An employer cannot maintain that reassigning such an employee to a reserved light-duty position imposes an undue hardship simply by showing that it would have no other vacant light-duty positions available if an employee became injured on the job and needed light duty. On the other hand, an employer need not create light-duty positions for ADA disabled employees, even when it does so for individuals with occupational injuries. Second, the ADA's focus on the essential functions of any job. Anytime I say essential functions, I want you guys' brain to register. Job descriptions of a job may complicate an employer's ability to curtail absences. By the way, if you don't have the job descriptions, you will never be able to work with essential functions. A problem may arise later if the employer refuses to hire a disabled applicant for the same job because the applicant could not perform the job's essential function. What are the job's essential functions? Once an employer accommodates an injured worker by reducing the duties of that position. Are the pre-accommodation requirements of the job position claim that the job's reduced duties represent its truly essential functions, and that the employer more demanding regular requirements are an unfair barrier to employing an otherwise qualified individual with a disability. Unfortunately, there is no settled case law in this area and no clear answers. So this is another thing I hope you guys walk away with. You're going to learn all of this stuff about leaves of absence, and it could change on a dime tomorrow if we have a significant case that turns it all around. So what we have to do is to do our best to make sure that when we do put somebody on a leave of absence, that we have reviewed everything that could potentially end up in a courtroom. Employers should continue to make use of a job modification and light duty assignments as a way of getting injured workers back to work. Under FMLA, an employee is entitled to return to the same or equivalent position. There is no undue hardship or no business realities defense. Indeed, an employee has the right to refuse a light duty position except in certain circumstances of intermittent leave and remain on FMLA for the duration of her entitlement. Thus, an employer's attempt to return a temporarily disabled employee to work on a modified work program through the workers' compensation system may violate FMLA if an employer requires an employee to take a modified work assignment. Therefore, an employer cannot require the employee to return to work, penalize them, or for failing to come into work, or force the employee to accept a reduced or modified work program under the FMLA or CFRA. The areas that we get into trouble the most are workers' compensation, pregnancy disability leave, and FMLA and CFRA. In administering its workers' compensation return to work program, an employer must proceed cautiously. The Department of Labor's the DOL, you guys heard the term, Department of Labor, wage and hour division states that if FMLA entitles an employee to leave, an employer may not, in lieu of FMLA leave entitlement, require the employee to take a job with a reasonable accommodation. This means that an employer may not enforce mandatory return to work programs until an employee has exhausted their FMLA entitlement. After that period, an employer can require an employee to return to work at some modified position, and the failure to do so could result in termination. So this is where the first time we're now saying, we've offered them modified work, they're refusing to take it. Can't do that under workers' compensation. All of these things that we do when it comes to modified work, light duty, needs to be consistent throughout our organization so that to make sure that we treat everybody the same way. However, taking into consideration all the different kinds of leaves that we have. The employer's right to transfer an employee taking intermittent leave because of pregnancy-related disability to an alternative position includes the right to alter the employee's existing job to better accommodate the employee's need for intermittent leave or a reduced work schedule. The employer may not require if the employee does not request it. So there's that thing that I think is really important right here. The final sentence, and I think now that I'm going back and reading all this stuff, they're saying that the employer is required to do this if the employee requests it. But the supervisor may not say, I need to move her out of this job because she's pregnant. California Labor Code does not appear to mandate that employers create temporary light duty positions. However, I always did. Employers generally use job modifications and light duty as cost containment measures to get injured workers back to work at the earliest possible juncture. Also, Labor Code Section 132A's proscription on discrimination against industrial injured workers means that an employer may not treat industrial injured workers less favorably in assigning them light duty and may not refuse to place an injured worker who requests light duty in such an assignment unless justified by business necessity. It's kind of like you could just make these little bullet points or a checklist. Do you need to know all of this stuff? You do, but it needs to get sunk into your brain more than anything than the details that I'm presenting to you today. Honestly, after 40 years of being in human resources, for my clients, when we have leave issues, I take that checklist and I go down it just to remind myself not to miss a thing. Okay, other important excused employee time off. Alcohol, drug rehabilitation. There was a movie, I don't know, 90s, I think, called 28 Days. And it's a real thing. When somebody comes to you and tells you that they need a leave for alcohol or drug rehabilitation leave, you need to give them that leave. And generally, it could be 28 days in a rehab facility. It could be going to night programs. It could be going to programs that are just in the morning and we have to, allow them to, every time I think of alcoholism, I'm like, we need to enable them to go. And then we do have to remember, however, after 28 days, it's over. They don't come back. There's no job protection. Okay, you want to make sure that you have a drug-free workplace act, and that's where we can require employees who have drug or alcohol problem dependency to maintain the same job performance standards as other employees. One of the ways that I always know when a client calls and they've got an employee who, is late consistently on Monday. They're not feeling good on Monday. They come in, and their job performance is terrible, and yet on Wednesday they're great performers. I can almost say every time. I mean, I can't really say it, but I say, here's what we need to look at. Their long attendance record. Let's take a look at that. And then you need to, of course, discipline them the same way you would any other employee, but you really cannot mention that they have an alcohol problem unless you fall under DOT regulations. So if you fall under DOT regulations, you want to send them to the clinic and have them tested. Military leave. This is another one. This is sort of it's both California and federal law. So in California, we have a spinoff of the federal law. And really, it makes me crazy that we have to have these laws, because shouldn't just a normal employer say, your husband's home, or your spouse is home, or your wife is home, or your son is home, and just give them 15 days off of work to be with their family? Once they take longer than 15 days, they are no longer under protected job status. Okay, USERRA, Uniform Services Employment and Reemployment Rights Act, just goes a little bit further with the military leave, and it applies to all employees eligible to participate in the U.S. military service. But anything that has to do with military, if they get called to duty, they get to go. And I have clients who call me and they have like somebody who's in the reserves, and they get called and they have to go for like 5 days. That qualifies. They get to go for 5 days. Now, military leave applies to employers with 50 or more employees under the California and federal law. Okay, school visitation. A lot of people are shocked to know that when your kindergartner is doing a play in the kindergarten, you have a right to go see that play. So we have up to 40 hours, and they can take their vacation if they want to, or they can take it unpaid, but they still have the right to visit their kid's school. The other part of that, it also means, and this is what it was originally set for, was if you have a kid who's been suspended just, from school, and you have to go talk to the principal. Okay, that's an allowable leave of absence in California. And then it, of course, evolved into all of the things in California, like going to watch your kid's kindergarten class, do something. Employers with 25 or more must allow parents or guardians to attend up to 40 hours off per year to participate in school activities if you're in California. All right, we all hopefully know about jury duty. We have to allow our employees to go take jury duty. And boy, if you mess with that and the judge finds out about it, he will haunt your company for the rest of their days in business. Okay, domestic violence and sexual assault victim leave. This is a lot. I don't know that you really need a lot of explanation on this. If somebody has been, abused, beaten by their spouse, or sexually assaulted in any way, by law, we have to give them time off to go to court, write police reports, whatever has to be done. Once again, I don't understand why we have to lie. I can't imagine any employer not doing this, but then again, I worked for some pretty good employers. Alrighty, crime victim leave, same thing. Voting time off, we already talked about that. Volunteer civil service applies to firefighters and other emergency personnel. So if you got volunteer firefighter working for you, and there's fire, you got to let them go. Vacation paid time off, not required by law. However, if we offer it as a benefit, the following rules apply. Policies must be clear and include rate of accrual and when accrual begins. Vacation is a form of wages. So employees earn a portion of vacation each day. There's no use it or lose it. Caps are allowed. And accrued but unused vacation must be paid at the end of employment. Holidays, they are not required by law, but if we have them, we have to have a policy that says what they are and whether they're paid or unpaid. And we already talked about paid sick leave. I think this slide is in there because paid sick leave sort of overrides kin care. Under kin care, you can take half of your sick leave benefit to care for family members. But under paid sick leave, you can take all of it. So I think we're going to find kin care disappear pretty soon. Bereavement leave up to 5 days, which could be even more. You have to be employed for at least 30 days before taking the leave. I don't know about that. I certainly hope the employer, would have, like, I will tell you that I started working at a company, and on the 4th day I worked there, my dad died, and my company gave me as much time as I needed to take care of business, and I'd only worked there for 4 days. I will tell you, I was the most loyal employee ever. I stayed with that company for 5 years, and I didn't leave until they sold to somebody else. I would be there today because of that. Paid family leave is not a leave. Although there are some senior HR people who will argue about this, but it is not a leave. It is a wage replacement program. So it provides eligible employees with partial wage replacement, but does not provide any job protection return rights. Literacy leave. If somebody can't read, we need to give them time off to read, learn to read. Religious accommodations. Employers must reasonably accommodate employees' sincerely held religious beliefs or practices unless doing so would impose an undue hardship on the business. Some examples could be flexible scheduling, voluntarily substitutions or swaps, job reassignments, lateral transfers, and modifying workplace practices, policies, or procedures. Undue hardships, and I have actually seen this happen. The accommodation requires more than ordinary administrative costs, diminishes efficiency in other jobs, infringes on other employees' job rights or benefits, impairs workplace safety, causes coworkers to carry the accommodated employee's share of potentially hazardous or burdensome work, or conflicts with another law or regulation. Reproductive loss leave. Employees who work for employers with 5 or more employees and have worked for the employer for at least 30 days before taking leave can take leave following their own reproductive loss event or that of another person, such as a spouse or a partner, if the employee would have been the parent of the child born or adopted. All right, so you have been put on notice. What is the first thing you should do when you learn that an employee needs one of the following leaves? Paid sick leave, CFRA, FMLA, and PDL. So this document here is called the Notice of Eligibility and Rights and Responsibilities. So it is telling the employee that if they are going to go on a FMLA leave or a pregnancy leave or a CFRA leave, that they have certain rights and responsibilities as well. Now, it is up to the employer to make sure that they know what their rights and responsibilities are. And that means that they have to let the employer know when they're leaving, when they're coming back. They need to have the doctor or a healthcare provider fill out a portion of it explaining that they have this job protected, a need for a job protected leave. The reason why I include PSL there is a lot of times when somebody applies to go out on their paid sick leave, they've already exhausted their 5 days. That's a trigger for you to think, they possibly might actually need FMLA leave. Same with vacation. They don't come back from vacation and they're asking for, they've used all their paid sick leave, they've used all their PTO, all their vacation pay, and they're still not coming back. It may be time for, and this is especially true in communities that are not completely educated on the American way of life. They don't, they don't know, like people who sit and watch TV where there's an attorney who's shouting out, we'll do this for you, we'll do that for you. So it's our job in human resources to shout that out to our employees when it appears that they need a leave. What does HR do? Number one, we confirm the need for the leave, and we do that by reaching out to the employee and providing them with their options by giving them that notice of rights and responsibilities. Everything is on there. I like to go over that form with them if I can. We can't always. Sometimes they're already out sick, okay, and we have to email it to them. It's possible that we need to take it to their home. Sometimes people mail them. I don't like mailing them because when people are sick, the first thing they do is not open up their mail. But the best thing is that you get notified before they ever go on leave, and you can sit down with them and explain to them what their rights are, but they also have certain obligations. And then you can take that opportunity to explain your leave policies and go through your employee handbook and say, here you have this leave, and this leave. And then also, of course, if they haven't worked for the company the right amount of time, then you may have to tell them that you're sorry that they're not eligible for this leave. Oh gosh, coordinate with payroll. As soon as you're put on notice that you have an employee who's going out on leave, make sure you do a change of status form. You don't give payroll the rights and obligations, but you do need to make sure that you have a change of status form. A copy goes to HR, a copy goes to payroll, and a copy goes to the employee. And that change of status form is going to say they leave on this date and we expect them to return on this date. Okay. And if they don't return, they will, there's legal language on there, but basically they're not going to get their job back. All right. Now, of course, we want to be extremely confidential with any information that we obtain, and you have to track and return your leaves. Normally, this is an exercise that we do, but again, we've already run out of time. Generally, when you're tracking, it's done on an Excel spreadsheet. If you're fortunate enough to have an HRIS, even most of the paychecks and all the different payroll companies, most of them have leave tracking options. Make sure that you track those leaves. Worst case scenario, put it on your own calendar, your own company calendar, that this is the day that so-and-so left, and put it on your calendar that this is the day that we expect them to return. Because it's very important by law that we follow up. We cannot expect the employee to follow up. We have to follow up. Now, we've given you this handy dandy little California leave chart. And what it does is it shows you how FMLA and CFRA and PDL and paid sick leave and ADA and FEHA. It shows you how they all combine together and how and what you need to do. This is a great little checklist for you to have. Thank you for joining the webinar. See you again soon.